Greetings, greetings, greetings. You are now tuned into the vault. Trust Christian, own nothing, control everything. Just want to thank you for tuning in live or listening to replay. Good day, good night, wherever you are in the world. Today we're going to be talking about the truth about living trust versus irrevocable trust. It seems to be a really big topic. The reason why I wanted to do it is because I've had so many clients and individuals inquire about the irrevocable trust, and so many people come to us previously because they're used to dealing with public lawyers, public attorneys, that they traditionally put them in traditional vehicles. And so today I want to discuss this living trust versus the irrevocable trust and talk about it. It's almost like saying public versus private, but that's not an exact thing. And so I definitely want to clear up some misconceptions, talk about some of the benefits, some of maybe the pros and the cons and things of that nature. But I always wanted to go there. I want to start with a very, very impactful story that I had. I don't talk about clients' names because of privacy, but I can tell you all the story about how I had a client come to us a while back, and she put her lawyer on the phone, which was really awesome. I was excited to talk to her about the lawyer. She was inquiring about trustee training, and I want to quote what our lawyer said about inquiring about what we do because we have a proprietary process with irrevocable trust as opposed to living trust. And the living trust situation isn't always the most beneficial situation because it doesn't follow the philosophy of trust overall. The philosophy of trust, in my opinion, is trust Christian. Here we go. Own nothing, control everything. Whereas in a living trust, people make this claim that they have giving up ownership rights, but they're still maintaining control over assets in a living trust situation. And because you haven't truly given up ownership because of the way that trust structure is set up in a living trust, you're still taxable. Those assets are still yours. They're just in a living trust. It's pretty clear and evident about a living trust. And so I think it's a very, very important topic to talk about because a lot of clients are traditionally put in these vehicles because of lawyers. So let me talk about what the lawyer says. So, I'm talking to the lawyer and, just asking basic questions. So what do you put your clients in? He says, we put them in living trust because they don't want to divest themselves of the assets. This is quoted out of a lawyer's mouth, ladies and gentlemen. I'll repeat it again. The reason why the lawyer does not put clients in a position where they completely give up ownership of assets, because in a living trust you do not give up complete ownership of the assets. You just place the assets in a trust for a trustee to manage, and in a living trust situation you still maintain some type of ownership slash control even though you're not the person managing the trust. And so it's called a living trust. And so the lawyer literally said to me, he said, hey, we our clients don't want to divest themselves of the assets. I can tell you right now, that's called a public education. That's a public education, ladies and gentlemen, because ownership incurs liability. What are the liabilities of a ownership? The liabilities of ownership are taxation and being able to be sued for those assets. And don't think somebody's not going to sue you for your assets, whether you have a lot of money or a little bit of money. And then taxation is different for businesses or trust as opposed to an individual taxpayer or an individual themselves. What's interesting about it is that in an irrevocable trust situation, you completely, as the grantor, the person that creates the trust, gives up complete ownership of the assets. You give it away irrevocably to a trustee. And so individuals say, oh, well, how can we do this? I say, well, look, in our trust system, we have a proprietary process to make sure that things are set up in a specific kind of way. Why? Because a trust is a contract. So there's creative ways we can get with contracts and things of that nature that are very legal. So when you talk to a lawyer, you can say, oh, okay, well, there was something that was created and you're the trustee over it, as opposed to a living trust where you created and then in turn, you actually didn't really give up ownership of the assets. And that's very, very important because we're talking about taxation, we're talking about being able to be sued for assets and things of that nature, and that's very, very critical. How does it work? A living trust, you create a trust and you have a trustee manage it. Whereas in the irrevocable sense, says, hey, look, if you give up ownership of the assets, you can never come back. So that's why you hear a lot of lawyers, specifically in the public say, oh, we don't want to, our clients don't want to divest themselves of whack because they're public lawyers. They know how to do public processes. They're going to set you up in a legislative entity. They're going to set you up in a public entity because they're under legislative rule. That's why they're public bar lawyers. And so, as a private trust consultant, I have the ability to work with people at very high levels that are very understanding of this. And they say, well, look, if it's going to put me in a position where I'm still going to be able to be sued, help me not do it. If it's going to help me put myself in a position where I can avoid taxation personally, which is the worst taxation, help me do it. Why do you think public lawyers can't do it? Because you're supposed to be able to go to that lawyer and say, I need this to be done this specific way. That's why when you go to a lawyer, you say, hey, set this up for me. Well, if they don't know how to do that, then that lets you know that there's less than 2% of the lawyers in the country, because there's less than 2% of the lawyers in the country that can actually efficiently and effectively put you in a position where you were tax avoidable personally. I talk to lawyers all the time, and they say, oh, we put our clients in S corps. Why put a client in an S corp when it's double taxation? I hear it all the time. You know how many entrepreneurs I know that are legally classified with their companies as S corps? One of the worst entities to operate in right now, in my opinion. Definitely best to go with an LLC or a C corp. Very clear, very understanding. Whereas trusts, they give you a lot more flexibility. They give you a lot more control. But remember, ladies and gentlemen, there's over 80 different types of trust. You all can go look this up on your own. But it's very important to understand that the irrevocable trust puts you in a position where assets are given away and they can be controlled by trustees, and assets can be grown for the benefit of the beneficiaries. And there is no benefit to you as the grantor. So that's why we have a proprietary process in place. And that's something that's very, very important. When you start understanding how to operate as a trustee, you learn how to take advantage of what's called fringe benefits. Fringe benefits as a trustee allows you to have meals. It allows you to have, transportation, a clothing allowance, a food allowance, things of that nature. The same thing that any corporate CEO is taking. Because you are the trustee, you're not the CEO, you're the trustee. Sometimes, in our case, we don't take salaries. Why? Because if we took salaries, that would put our social security numbers back in position to be taxed personally. So we don't do that. So when you hear people like Robert Kiyosaki, my mentor, or you hear people like Donald Trump that say, I don't pay taxes personally, it's because they put themselves in a position where they have the correct vehicles in place. And this is how we maneuver through society. And so I just wanted to share these ideas with you today because a lot of clients, like I say, come to us with this living trust concept. And the living trust concept still makes an individual taxable, still gives an individual the ability to be sued. What if you could be like a politician? Like I say, there's over 80 different types of trust. I'm going to mention this trust and then I'm going to do an episode on it. It's called a blind trust. So individuals, such as politicians, put their assets inside of a thing called a blind trust. In turn, that means they give away, to a degree, money inside of a trust. They give it away blindly. That means they don't know what's going on inside of the trust, what the trustee is investing in to grow the assets. And I'm not going to delve too deep into it because I really want to save it for the next episode, which I'll do tomorrow. But the whole point of it is for them to shield themselves for a conflict of interest. And that's what we're all looking to shield ourselves from, is a conflict of interest. It's sort of like if you work for a company, you can't go out and start your own company competing against that company. Very, very important. So it's the same thing with the blind trust. It puts you in a position where you're adversely putting yourself in a position where you don't know what's going on in relationship to what the trust is investing in and growing the assets in for the benefit of the beneficiaries. And so the irrevocable trust can be utilized as that, but clearly the living trust cannot be, because the living trust, you can always come back, you can peek your head in, you can see what's going on, you can fire the trustee, things of that nature. Why? All you did was just create a entity that is going out and acting as a separate legal person, which it is. A trust is a separate, distinct legal person. But in turn, if you pull back any type of profits or benefits to yourself, you will be taxed. That is a living trust. You're still alive. The trust is going based off of your command and what you want to have happen. How's that beneficial? You're still going to come back and you could possibly be sued for things. Those assets aren't completely not yours, they're still yours. So the irrevocable put yourself in a position where you're able to give away assets and assets can grow. Like I say, we have a proprietary process in place that enables you to utilize irrevocable trust because those things are very, very important when you operate internationally. I hear a lot of times, especially from senior trustees, we teach senior trustees that, United States citizens, if they have trust, they're considered almost United States property. So we put things in a position where the United States doesn't have any control over the assets at all. And the United States definitely wants to have assets over uh, those assets, has control, wants to have control over those assets. You could almost say that the living trust is public and the irrevocable trust is private, which puts you in a position where one is under the rule of the state and the other one is under contract law, and contract law makes the law, and that means that the contract is the law. See, individuals don't understand that they think that the law is very stagnant. It's actually very dynamic and free flowing. And when you understand contract, which contracts can be amended and updated, that's why they update contracts in the public all the time. Laws, quote unquote, a law is a contract. That means you have to agree to it. Then you see that there's a lot of flexibility and dynamicness to growing and changing and amending laws inside of the contract itself. And so I really wanted to share those benefits today with you all, to let you all know that that is what we provide at the Vault is trustee training. It's a private trustee training, a private forum. And so we always make it a point to put our trustees in a position where they own nothing, control everything. And so if you all have any questions, feel free to email us at christian@trustchristian.com. I'm live right now on the chat. So if you all want to chat with me live about the living trust and the irrevocable trust, that'd be great. I do welcome the questions to avoid a consultation. But at the same time, if you all would like to deal on a more private and intimate level, feel free to contact us, the vault at christian@trustchristian.com, and we can make sure that your situation is specifically handled. So I just want to definitely talk to you all about that living trust and irrevocable trust situation. I get a lot of that from our clients. So I don't really see any questions in the chat here. I do want to thank you all live or listening to the replay. We have gotten a ton of inquiries over the past week, from real estate investment trust to, I'm sure we're going to have a bunch of people that have living trust and they're like, there's no protection here. I really don't know how to work it. Think about it. When you're in a living trust, think about it. These lawyers that are selling you all living trust. Why are they not educating you on how to operate as a trustee? You want to know why? Because you were supposed to know how to do that. And this is why, because in a legal dictionary, it says a trust is a secret. So inside of this secret entity, you're supposed to know how to operate in it. That means you're going to do your due diligence as an asset manager and asset grower inside of the trust as a trustee. That's the difference. And so we make sure that trustee training is important. Not just the setting up of a living trust to try to shield yourself from litigation or asset protection. Those things are important, but being able to operate as a trustee and grow the assets of the trust is the most important aspect of being a trustee. And this is why you see so much going on in the public about trusteeship, and that's very, very important. So we have a question here. Greg Clark, thanks for tuning in live, and Mark Man, thanks for tuning in live. It says, Greg Clark says, units of beneficial interest, example of its application. Units of beneficial interest, there's many different names for it. They can call them capital units, trust capital units, units of beneficial interest. They're still, long story short, is that's a beneficiary certificate, quote unquote. And so by them having a beneficiary certificate, that means that they have rights to the property, but that doesn't necessarily mean that they are in control of the property. The trustee is in control of the assets, growing the assets. The beneficiary is more of the position of benefiting from whatever the trustee gives them. That's the facts. Whatever the trust says that the trustee can give them. That's the fact. And so the beneficial interest position is not always the best position to be in. I think that's the position that most traditional people are in publicly. They're in a position of beneficial interest, which means they're receiving benefits, which means they're going to be able to be taxed. So, let's just say there's a disbursement to the beneficiary. That means that they're receiving some type of financial reward, most likely from the profits of the trust over that period of time, however long that period of time is. for them to receive benefits, and in turn, that's like them receiving an asset personally. Remember, this isn't personal. This is business. We live in the United States. The United States is a commercial vehicle. It's a commercial entity. It's a commercial enterprise. There's nothing personal about it. It's always business. So putting yourself in a personal position encourages what? Lawsuitability. It encourages what? Taxation. And so we want to put everything in a position where we can take write-offs. I mean, let's think about this, ladies and gentlemen. If it's business, let's take advantage of what the IRS says we can utilize the write-off. Ladies and gentlemen, everything I'm talking about is from the IRS. These are individuals that are quote unquote setting the standard for rich people. Rich people are running the IRS, ladies and gentlemen. Rich people wrote the tax law, not poor people. So let's be very clear that rich people wrote the tax law. And so in turn, beneficial interests aren't necessarily always the best position to be in. We don't recommend that at all. That's not something necessarily that, is a great position to be in, but it does give an individual the opportunity to not necessarily control. Let's just say, for example, it's a house. The trustee was given the property inside of a trust, and the trustee's managing the property. Well, the beneficiaries could be the children of the grantor, quote unquote, and the beneficiaries are the children, and they just want to benefit from living at the property. And so the trustee is making sure that the mortgage is being paid. Well, as soon as the beneficiaries start taking money out of the property, or the trustee starts giving them benefits to finance, in turn, that makes the that in turn makes the beneficiary taxable. That means they have an interest. Anytime you have an interest in something, you can also be taxed on something, because if there's a profit gained off of the interest, profits get taxed. And so it's not always beneficial to be in that position of a beneficiary interest position. It just, to me, it's not necessarily the best position to be in. Can your children, some people, another example is people will say, well, what about my children? Say I'm in a trust system and I'm the trustee and my children are going to benefit. This is what we do. I'll tell you straight out. Our children are successor trustees. They don't become beneficiaries after we pass. They are trained in what we do, and they become trustees in the trust, period. They understand how to avoid taxation. They stay in a tax avoidable position. We don't put our children in a position of being taxed. We stay in a tax avoidable position. So in turn, the children become successor trustees, and they continue to maintain control over the assets, but they never own it. And sometimes beneficiaries can be confused with an owner. That's kind of, that's not a good look. So not a great position to be in my opinion. Mark Man says, can you be sued with the living trust? So of course you can. You can be sued, and like I said, you can go do your own research. You can even call a lawyer as soon as we're done with this recording. I encourage you to, and say, hey, I have a living trust. Can I still be sued for my assets? And those assets are a living trust. Can someone come after those assets? And I guarantee you, yes, they can. Because in a living trust is set up and you did not give up complete retention or control or ownership of the assets. You can go back and dissolve that trust and get all of those assets back in your name. That's not irrevocable. Once you give away something irrevocably via the law, that means you will not be able to come back via the law. Very important. You're welcome, Greg Clark. Thanks. So we're going to continue talking about it. Mark, man, that's definitely when you're talking about those type of questions, man, the trust certificate units, look, can it be used as an asset if the trustee allows you to, depending on the type of trust that it is? But I don't recommend utilizing those things as a beneficiary. So and just not a good look from my opinion. Uh, Greg Greg Clark says beneficiaries cannot administrate. So great question. There's a law, or excuse me, there's a doctrine, I should say. There's a doctrine called the doctrine of merger, where it says that you cannot hold two positions inside of a trust solely. So that means you can't be the beneficiary and a trustee by yourself. You have to have someone else in one of those positions. Otherwise, it's almost like, an alter ego. The IRS is going to look at that as an alter ego. Are you managing it, quote unquote, administrating it as a trustee, or are you the beneficiary? So that's one of the questions that I would pose to you, because when IRS looks at you, they're going to say that. They're going to be like, well, whose is this? First of all, the trust has to be its own entity. And if you're a beneficiary, that means you're benefiting from the trust, but then you're also the trustee and you're not doing it by yourself. So there's no real adverse position there. It's a full beneficial position to yourself. or the individual that's in both of those positions solely. So the doctrine of merger, I encourage you to look up that so you can actually understand and get a better understanding of what that really means as far as being able to be a beneficiary and a trustee, quote unquote, not just an administrator, but a beneficiary and a trustee, and be solely those positions at the same time by yourself. As soon as you have someone else in that position, not by yourself, then you also you're in an adverse position because you're not the only one in that position growing it. And like I say, everything I'm talking to you all about, ladies and gentlemen, I talk to lawyers about. So you can feel free to talk to a lawyer about exactly what I just mentioned to you, because you do want to stay compliant with the law. That's the whole purpose of what we're doing. Everything needs to be done by the law. You don't want to be in a position where it's not. So I encourage you all to really think about that. Any additional questions, I'll answer them. Otherwise, I'm getting ready to wrap up the episode. So any additional questions on the live stream here, feel free to go ahead and ask. Remember, trust Christian, own nothing, control everything. Live in trust, you're still owning things. Irrevocable trust, you've given up ownership. I'm not telling you that you maintain control, but you're giving up ownership. And that's very, very important in an irrevocable trust, but you have to be in a trust the correct way. And there's many different ways to have these entities set up. We have another question from Greg Clark. Can a beneficiary be a place or a thing? Great question today by Greg Clark, coming with some great questions. Yes, a beneficiary, when you say a place or a thing, just remember, I'll give you the definition of a person in law. Are you ready? Is a corporation, is an S Corp, C Corp, LLC, or trust. That's like asking, and I'll share with you all, these are the facts. A trustee can be a trust. This is why you see Rockefeller had over 8,000 trusts. How do you have over 8,000 trusts? That means that you had trusts that were trustees of trust, and you have beneficiaries that were trust of a trust. Because trusts are persons in the eyes of a law. A corporation is a person. That's why when you all go back and Google Mitt Romney, he says corporations are persons. They can file bankruptcy. Can a corporation file bankruptcy like a normal, traditional, individual taxpayer? Yes, they can. That's why the United States is operating out of a bankruptcy right now. Because corporations are persons, and those persons can file bankruptcies and also still operate from a receivership position. That means they haven't necessarily given up all of their assets over, they just are able to still operate. Very, very important. So yes, I wouldn't say a place or a thing. It has to be a person. And when I say a person, like I say, it can be a corporation, S Corp, C Corp, trust, things of that nature. Association, beneficiary can be an association benefiting from a trust that is giving it beneficiary interest in the property that's being held, or the benefits that the trustee is giving to those individuals, or quote unquote at that association at that time. Mark Man, let's get this question. Once I buy a house and I put it in my common law irrevocable trust. So I'll go ahead and stop you right there. Remember what I just said. If you say it is my common law irrevocable trust, that means you didn't give up ownership. If you put it in let me say it in my terms. If I put a property in my trust, does that mean I gave up ownership? No, it does not. So we'll go ahead and stop it right there. No, and it will not prevent a foreclosure or taxation. Why? Because you did not create an entity in the proper capacity to actually be labeled as not yours. As long as it is yours, you can be taxed or sued for it. So that's the difference between irrevocable, making sure it's properly set up irrevocably, and it not being set up properly irrevocably. And that's the distinguishment between the trustee training at the vault and the rest of these public attorneys out here that are following suit. And think about it, ladies and gentlemen. If they're putting the average individual, or most individuals, in a living trust, what happened to the other 79 trusts that are out there? Why don't they mention those trusts to you? Because public attorneys have been given what's called controlled knowledge. They went to a public school and they've been given public information. Private trustees or private trust attorneys, Google them. Where are those at? Because the company Google, you can Google this, Google didn't pay taxes on $75 billion. And the EU slapped them on the wrist with many other multinational trust companies, ABC Company, Alphabet Company. And what did they say? They say, can you just give us 1.2 billion? Can you give us $3 billion? You made 70 billion in our jurisdiction tax-free. That's because they understand how to divest themselves of ownership. So when you see individuals such as Steve Jobs, such as oh, I got to do Steve. And Steve said, no, no, no. I'm going to go to one of my favorites, actually, of goldmoney.com. Gold, G-O-L-D money.com, M-O-N-E-Y.com. Roy Seabag says he is the founder and CEO of goldmoney.com. He pulls down a salary of $1. You can Google this, ladies and gentlemen. The company is revenuing over $500 million a year. Why would he be pulling down $1? Because he's set up properly. That's why. So we got another question. Copatone Bay. It says, question, can a trust purchase land or property? For sure. Thank you for tuning in live. A trust is a person, and a person can do everything that me and you can do. It can buy, sell, hold, and lease property. The reason why we're talking about this is for a simple reason. Taxation and lawsuit ability. This is called asset protection and asset separation. A trust can buy, sell, hold, and lease property. It is a person, just like that's why they call it a legal person. Just like your individual taxpayer situation, and just like a corporation. Please go Google Mitt Romney with the whole corporate personhood. Corporations are pleading poverty. How is the United States one of the largest entities in the world, corporate-wise, and it's in a bankruptcy right now? They are over, $19 trillion in debt? That'll let you know how things are operating, really, whether it's publicly or privately. That's the difference, ladies and gentlemen. Thank you all for tuning in live or listening to replay. Feel free to go back and tune in. Share this with your friends and family, your community. I did something on real estate investment trust. Please feel free to check that out if you all are crowdfunding or pooling funds together to acquire real estate investment trust. There's different ones, public and private, that are great to tap your hands into, or you just want to separate some assets and make sure that you can't be sued or taxed out of them anyways. So thank you all for tuning in live. Peace and blessings. Thank you all. Have a great day. Look forward to sharing with you all tomorrow. Tomorrow I'm going to be talking about blind trust. It's going to be a great one. All your politicians are using blind trust. Why aren't you? These guys are claiming that they don't make any money, but they're still getting their pensions of $200,000, $400,000 from the government that you're paying taxes with. This is called put yourself in a proper position to receive your wealth, grow your wealth, and pass on your wealth tax-free.